Thank you for joining us. These type of webinars are very beneficial to people because it gives them the opportunity to pose a direct question to a legal practitioner that specializes in family law. You may come across your specific legal problem for the first time and do not know how to deal with it. Sometimes it's very useful to engage with a legal practitioner who practices or who specializes in the specific field of law, and he or she would be able to fast track your knowledge on this specific topic. Therefore, as I've always welcome people to pose whatever questions you have. I see we have a live question. Thank you for that. Let me read it out. My daughter's father has opened her an Instagram, Facebook, and TikTok account. She is only 9 and I haven't been consulted about this. Is there anything I can do to protect her from this or do legally? It's a difficult question to deal with. It's not a criminal offense for him to open such an account unless Facebook or Instagram does not allow it, or they might allow it but with parental oversight. And some parents, for a 9-year-old child, they might find it reasonable for him or her to have a Facebook account whereby they will keep a close look out on it. So they will monitor it. Generally, parents would have to discuss these specific things. They cannot, at every point where modern technology comes in, where certain decisions regarding a minor child has to be made, they always add loggerheads. So here it is now the Facebook account where the parties now have an issue and a problem regarding that. I'm not referring to this specific commenter. A different scenario would be where the child has to get a cell phone. Parents are now at loggerhead. Maybe if they were in the same in one relationship, living together, they would have resolved that specific issue more differently, but they do not, or they cannot. Now, this is a typical issue where the parents have to discuss, they have to work around it, because if Facebook is lawful for a 9-year-old child to have an account with, I do not know, I have not done the research, this is the first time I have had a question like this. And if it is legal and a specific parent wants to have that, that is now obviously that parent's decision. But if you feel that it is harmful and it will cause some type of negative impact on the minor child, and it will actually happen, then the only way I can see this matter can be resolved would be for you to approach the court of law and ask the court to force the parent to stop with the action of creating social media accounts for the specific minor child. You cannot go to the police. What will the police do? It's a Facebook account. What will the charge be? Opening an account for a minor child, unless there are illegal activities taking place on the account. So therefore, please verify firstly whether or not a 9-year-old child can have a Facebook account, or is it the father's account whereby he's posting pictures of the minor child day-to-day activities. But from a point of view, parents should be able to discuss this. As I mentioned early on, tomorrow there will be a different problem, something else, and these specific parents cannot agree upon these things. If the parties were in a relationship, they would have discussed it, they would have argued it, and they would have made a decision regarding that. So from a legal point of view, I cannot really see any recourse as, for example, going to the police station and so on. The other recourse would be to contact Facebook, to contact TikTok or Instagram and say, this is a 9-year-old child, please close the account. But I'm certain they can open up an account again on a different name and a different username, etc. The only option I could see or presume would be to approach the High Court, and the High Court will have to make a decision if it is in a child's best interest. It can be very expensive. But then tomorrow there's another problem, another issue. Co-parenting counseling, I would say that's most probably the best thing to do, because when it comes to these type of things, the parents have to agree upon it. And if they cannot come to an agreement, what does it mean? The account shouldn't be opened, or the action should not be taken place, or if they cannot come to an agreement and the party who proposes something can go ahead with his or her suggestion, for example, giving the minor child a cell phone or not, That is where counseling and co-parenting comes in. The best of co-parents are the best of parents, and that is best for the minor child. The commenter went further and says to put a stop to it, as she was told by her dad to keep it a secret. It's clearly a family issue. It's not necessarily a legal issue. Tomorrow the child, not the specific commenter, I will never refer to anybody specifically who comments, that will be wrong upon me. But let's say tomorrow we have a scenario where the father lets a minor child wear a certain type of clothing. It might be inappropriate for that specific family environment, and tell the minor child, please keep quiet. Do not tell your dad or your mom about this. So whenever the child visits the mom or the dad, the child is allowed to do certain things, or the child is allowed to do swimming or cycling or piano. The parties might be very religious at the father's home, and when the minor child is at the mother's home, they might not be so religious, or they might engage in conduct which is not allowed religiously, but it is allowed legally. From a general point of view. What do you do then? Clearly, parents need to discuss these matters, come to resolution. And my advice, as I mentioned earlier on, are for them to actually go to a professional and to discuss these matters. If they cannot, they need to go to a court of law, and the judge will decide whether or not it was justifiable for the matter to have come before him in the first place. Let us move on. I got an additional question from someone else. The comment of earlier on, you're welcome to add additional comments, and I'll be happy to answer them. The comment is as follows. If there is a garnishing order, how do I get the yearly increase? Unless a garnishing order specifically states that the amount get increased every year, the order. So basically, there will be a maintenance order in place stipulating that the one parent should pay X amount of maintenance per month. If that specific order says there is an annual increase, either in terms of the CPI, the Consumer Price Index, alternatively an amount of 10% or 12 or 15%, whatever the parties have come to an agreement with. If there is such a clause in the maintenance order, and the order becomes enforced in a garnishy way, in the sense of the one parent is not paying the maintenance on time, and now the employer is now ordered to pay the maintenance. If there is an increase in the order, the employer will be forced to pay the annual increase. If there is not, then there needs to be an application will have to be made to the court, and you will have to ask the court for an increased amount, and at the same time try to convince the court that you require CPI to be implemented, because you cannot come to court every year, etc. The challenge I have with CPI and the annual increase of 10%, it might work should the minor child be in primary school. But as the minor child gets older, the expenses changes. He might all of a sudden eat double the amount of money, and therefore the 10% might not have been appropriate. So the ideal would be to approach a maintenance court every year based upon the current circumstances. However, that can be tiresome and obviously expensive. You'll be making use of lawyers and so on, and losing time at work. Therefore, on that note, I would always advise people, the order should specifically stipulate that the one parent should pay for the following expenditure. For argument's sake, either half the school fees or pay for the medical aid, and you work those specific things out. And the cash contribution that actually gets garnished by the employer, that only relates to generally food and maybe clothing. And if you are dealing with the issue concerning school clothing, the order will specifically stipulate that the one parent should pay half the school clothing. So although the school clothing increases every year, maybe by 20% or 30%, that is possible. Or if a minor child this year requires no school clothing, maybe only socks and a trouser, by next year he or she might require a blazer and so on, which will increase the amount greatly. The order will stipulate that he or she should contribute half of that specific expense, which makes life much, much more easier for the parties. Therefore, coming back to the questioner, unless a court ordered a garnishee amount to be increased annually, there's nothing you can do. The same way, even if there was no garnish order in place, someone has a maintenance order in place. It says that one party should pay a maintenance amount of 500 Rand per month. I'm using simple figures. and he or she does not pay, sorry, and he or she pays every month 500 Rand per month, every year. So the years are going on, and the question will be posed: how do I get the CPI an increase? You will have to approach the maintenance court. I speak under correction, but my understanding is that the maintenance courts do not out of their own stipulate CPI or increased amounts in the order. They expect you to come back to the maintenance court. I might be wrong. I'm certain some maintenance court might have a different approach regarding that. But my understanding is that unless the parties agree on an annual increase, they will only make one amount. And if you require more money following year, you should make an application to court. And the amount the following year will not be based upon CPI or 10%, but the actual needs or the actual reasonable increase that is required. It could be 20% as well. Thank you for that. If you have any additional questions or additional comments, please feel free to pose it. As I mentioned early on, I am watching the Advocate Muhammad Abduroaf Facebook page, Facebook Live. That is where comments should be directed to, and where I will respond from. These specific videos are streaming on other Facebook pages as well, and on other Facebook groups. If you pose a question on those specific groups, I will not see it unless it's on the Advocate Muhammad Abduroaf Facebook page. Then I will definitely see it. Okay, moving on. Child custody and child maintenance, serious topics, serious issues. I have explained quite in depth yesterday how challenging these specific topics are, the challenges that me as a legal practitioner face, and the challenges that you as a parent would obviously face when dealing with these type of matters. But having said that, life is challenging, and important things are usually, worthwhile fighting for. Therefore, if you and the other parent can come to an agreement regarding child custody and child maintenance issues, I strongly advise that you guys seek professional assistance, either going to a mediator, an attorney, someone to assist you in resolving these specific issues. If you cannot resolve these specific issues, unfortunately, you will have to approach a court of law. A question which has come to my table quite often, and which I might have mentioned it previously, is what is the connection between child maintenance and child custody? Or in other words, if I'm paying child maintenance, does it automatically mean that I am entitled to have custodian rights, contact rights, etc. to the minor child? That question gets posed, and obviously that question will have to be properly answered. The quick answer would be no. Those are two separate issues. Child maintenance and child contact rights, guardianship rights are two separate issues. You can have the scenario where a parent pays no child maintenance, nothing, zero, and have contact to the minor child every single day. And also you can have a scenario where one parent cares for the minor child consistently, does not have an income. For argument's sake, the mother, she's at home, she's unemployed, she's caring for the minor child all the time, she has no money to support the minor child. The other parent is paying for all the minor child's needs, but the other parent in this scenario would be the father. He has no rights of contact. He can most probably see the minor child once a year, once a month, once a week, whatever the case may be, although he's funding the minor child's lifestyle, which he should do, because the other parent is unemployed. Because if he does not do that, what happens to the child? How does the child eat? If you have money in your pocket, the other party is not working, how does the child eat, or how does the child survive? We have to look past our egos. We have to be reasonable and focus on what is best for the child. And at the same time, a parent can say, I'll be paying more maintenance. I'm seeing the child for 1 hour a month. What if I give you now double the maintenance? I give you now 10,000 per month. Judge, I would like to have more contact because now I'm paying more. I've got a better job and I can pay more maintenance. Two separate issues. I have another question, or I think it's a further comment from the previous question regarding the garnish order. It says the following. Will that be an original order? Where clothing is concerned, the order he was ordered to buy X2 yearly, so it's 2 times a year, and has not increased. How to go about that as well? Yes, the original order will have to deal with the annual increase and the CPI. The garnish order is not a new order. The garnish order is basically a clause. So there is a current order in place for the father or the mother to pay child maintenance. That's the original order. There is an issue in place where the father or the mother does not pay the child maintenance, but there is an employer. So a second order gets drafted, ordering the employer to pay the money over to the mother in our scenario. So it's an order. You can have 4 garnish orders in place. You can have one garnish order against, a garnish order against different employers if the guy or the mother works at different places. But the original order stipulates the amount. So that is the case. So if I look at a scenario, you will have to apply to the maintenance court for an increase. Look at the entire situation. Look at the issue concerning clothing and so on. He has to pay clothing. He has to purchase the clothing if the court order says that. If the court order is a bit vague and it doesn't work so well, then you have to go back to the maintenance court and say, you made an order stipulating that you should pay clothing twice a year. You must purchase a minor children twice a year. You did not stipulate how much clothing and so on. But this is what the child requires. They require a jacket, shoes, whatever the case may be, applicable to your kids. Each family is different. Some families require more, some families require less, some families does not require that specific item at all. And you say, these are the issues which I'm facing. Please, magistrate, please, court, please change the order so the order can be more workable. So the order might have to stipulate either he should give you a sum of money, which can be complicated because every year those amount changes, or this year the child requires a jacket, but jackets cost more money. Like the price of ginger and garlic, all those things have gone up and we didn't expect that. But be that as it may, look at the current situation, look at the problems you have, and make an application to the maintenance court to fix all these specific problems. Anything is possible. The court will have to decide what is best for the minor child. However, the amount and the items the party must pay will be solely based upon the needs of the minor child and what the parties can afford. I hope that answers that. You are welcome to pose additional questions and I will see it and I will try to answer it. An additional question. My ex is applying for shared custody now that I have applied for an increase in maintenance. We have a mediation now at 11 of our finances. He is going to use the pending case at Children's Court to delay the increase. Is this possible? Maybe before I answer that, the ultimate maintenance amount will obviously be based upon the movement and the life of the child. If a reasonable amount of money to be paid for child maintenance is 100 Rand, I'm using silly figures again, is 100 Rand. But that is based upon the fact that the minor child primarily resides with the mother and she buys all the food, she buys all the clothing, she pays for the school fees and so on. That's amount. Now the matter gets re-looked at, the contact care arrangement gets looked at, and the child will have to spend half the time with the mother and with the father. Meaning that the father will used to spend only 4 days per month. 4 days per month. He saw the child every second weekend, 4 or 5 days a month. Now we'll have to see the child or care for the child 15 days per month, 10 days more. The mother, on the other hand, will not have to purchase a lot of food, so much food at least, because the children will be eating at her place 10 days less, and so on. So therefore, the caring arrangements and contact arrangements in relation to the minor child has a direct consequence on the amount of child maintenance one parent should pay towards a minor child. If all else is equal, both the mother and the father earn the same amount of money, basically the same expenditure, and they come to some type of a 50-50 shared contract arrangement, then under those circumstances, it would not make sense for the father to pay the mother any amount of maintenance, because they earn the same amount of salary, they have the same expenditure regarding the minor children. Why should he now pay her? He shouldn't. It doesn't make sense. Unless, for example, she has additional personal expenses which are reasonable. Maybe her rental is a bit more, whatever the case may be. But it's a mathematical equation and you'll have to work it out. Going back to the Pacific commenter, yes, that is most probably what I would suggest my client. Before the maintenance matter gets finalized, the court cannot finalize it to finality until the finalization of the current custody matter. The court, parties can agree upon some interim arrangement. Let us say they finalize the maintenance matter, pending the outcome of a custody matter. Well, not pending, there is a pending custody matter. They finalize it today. The maintenance court says, based upon the fact that currently the father sees a minor child for 4 days and the mother cares for the minor child for the rest of those days for the month, the father should pay the mother 100 rand maintenance. 2 days later, the custody court finalizes their matter and they order that the minor child should live in both households equally, shared contract, 50-50. What happens then? Then the father will have to go 3 days later to the maintenance court and have the court order varied. The Pacific commenter mentions that they are busy with mediation regarding the maintenance. She says we have a mediation now at 11 of our finances. It doesn't seem it's a maintenance inquiry or for maintenance trial before maintenance magistrate. Mediation, even if there was no high court matter or 50-50 shared care matter pending before a court, no party is obliged to agree to the request of the other party in mediation. The same way, if this scenario, the father offers to pay a small amount of money, she is not obliged to accept it. And the same way, if the mother wants a high amount of money, the father is not obliged to accept it. Alternatively, even if the mother asks for a reasonable amount of money, the father is not obliged to accept it. He will be silly not to, but he doesn't have to, because it's a mediation session. It's an opportunity for both parties to lay the cards on the table and for everyone now to see what's what and what would be a reasonable amount of maintenance pay. If this mediation session does not work, I would say, based upon the mediation session, the party should come to some type of arrangement based upon the current arrangement. The current arrangement is that the father is not exercising 50-50 contact to the minor children, and therefore the maintenance should be reasonable based upon that. The maintenance matter should obviously be postponed until the custody matter is finalized, because then we really know how long or for how many days or where the minor child should or would reside during the Pacific month, so that we can work out the maintenance that should be payable by a party or not be paid. In other words, should there be a maintenance order in place if the parties are sharing contact and care equally, if both parents' income and expenditure are exactly the same? I hope that answers that specific question. I'm being very academic. I'm trying to be general. Obviously, the mediator will do his thing or her thing, and ultimately the maintenance court will have their own opinion based upon all the facts before them. The father will, of course, or his attorney will, of course, argue that the maintenance matter cannot proceed until the custody matter has been finalized. And obviously you will argue that no, it should proceed to the point whereby there can be a proper interim arrangement based upon today's circumstances, because the custody matter might not be finalized soon. It might take many months for it to be finalized, and because of that we need to come to a resolution now. and this resolution should at least be in place until the custody matter is finalized. I hope that answers that. I have a new question from a different person. I think this is now the 5th one. What is the consequences of a parenting plan that is not adhered to by the other parent? Serious consequences, but it depends. If the parenting plan was only signed by both parents, in other words, it was not made an order of court, it was not registered with the Office of the Family Advocate as provided for in Section 33 of the Children's Act. So there are two types of parenting plans, or finalization of a parenting plan. The one is it gets made an order of court. The other one is where it gets registered at the Office of the Family Advocate. If that is the case, what can I do? You guys drafted the document. Sorry, if the case is that you have not registered it or made it an order of court, it's just a piece of document basically stipulating what the parties have agreed upon, and it's regarding a minor child, so it's not really like a contract for the sense of I owe you money or I will do the following service for you for breach of contract, because minor children issues are looked at as current, as present, how it applies presently, and what is in the minor child's best interest today, not because the parties have agreed to it. If a party has signed a parenting plan and it comes before a court and the court decides no, and I don't think this is in the child's best interest, the court won't endorse it. If the parenting plan was made an order of court, obviously serious consequences can arise because you are in violation of a court order. If a parenting plan was registered with the Office of the Family Advocate and one party is refusing your contact, also serious criminal or serious legal consequences. The commenter of previous is thank you, you are welcome, regarding the garnish order. The commenter regarding the maintenance matter, the mediation and so on, made the following additional comment. Trial comments on the 2nd and 3rd of mediation if mediation does not work. So I'd imagine 2nd or 3rd of next month, because today is already the 3rd. Then the matter must finalized, and then get a finality on the maintenance matter. And then the child custody matter must still proceed, because that is not dependent upon the maintenance matter, and the maintenance amount is obviously dependent upon the child custody matter. I'll give you a different scenario. Let's say the parties are now in dispute. The minor children are in the care of the mother for that 26 days. They're on the care of the father for the 4 days every second weekend. Now something happened, the mother done something bad or she's unable to care for the kids, or whatever the case may be, the father thinks, now man, I think the children are old enough and I would like to have primary care over these specific minor children. The father now makes an application to court for him to be the primary caregiver, and the contact arrangements to swap, meaning the mother will see the minor children for a period of 4 days and the father will see the minor children for a period of 26 days. If that is the case, and that matter is pending, and now the court makes an order and proceeds with this matter to finality, based upon the fact that the minor children are in the mother's primary care, knowing that the High Court matter will be finalized also in a few weeks' time, soon thereafter. The High Court or the Children's Court, dealing with the application for primary care, makes an order stipulating that the minor children should now be removed from the mother's primary care and placed in the father's primary care. What happens then? Here the father has an obligation to pay 100 Rand per month to the mother, but she only cares for the minor children 4 days per month. And based upon the facts, and I'm using silly figures here, the 100 per month is way too much. It's applicable to someone who cares for the minor children for 26 days. And that's that. So therefore, I would say the sooner the maintenance matter can be, the sooner the the custody matter can be finalized, the sooner the maintenance matter can be finalized. However, my argument obviously would be if the custody matter is long, it might take another few months, maybe a year, then obviously the maintenance matter needs to be finalized now. And then in a year's time, whatever happens, the parties can come back to court. Thank you for that. I hope I answered your question. If you have any additional comments or questions, please feel free to post it and I'll try my best to answer them. We are now going into half an hour of the formal part of this video. We just passed half an hour. Yeah, but 5 minutes or so we were waiting for people to join. If you have any questions, please make use of the Advocate Mohammed Abduroaf Facebook page. If you would like to receive reminders on Facebook regarding these specific webinars and these videos, you're welcome to do so on the Advocate Mohammed Abduroaf Facebook page. I do not see any other questions, and I hope I have answered those specific questions to the persons who have posed it. I will be online again tomorrow, and this evening at 2 o'clock, I'm with an attorney. We will be discussing family law matters, and you are welcome to join in. It will be very informative and very, very interesting as well. Please share this video if you find it interesting, and I hope to see you at our next webinar. And please follow our page. Have a lovely day.